Hit the ground running, your voice in the middle of a crowd, and it's calling me in, but it's just the wind. My house, my empty house, I can tell that it's your footsteps walking down the stairs, but there's nobody there. It's what I wanna see, but it's not reality. Tell me if I'm getting colder. I still see your face. I see on my shoulder. I still see on my shoulder. 'Cause all I am is getting older. I still see your face. I see on my shoulder. I still see on my shoulder. Find me a stranger who looks just like you, maybe older and wiser and a little less bruised. It's what I wanna see, but it's not reality. Tell me if I'm getting colder. I still see your face. I see on my shoulder. I still see on my shoulder. 'Cause all I am is getting older. I still see your face. I see on my shoulder. I still see on my shoulder. I wanna go back to when I didn't have to pretend you were dead. I wanna go back to when I guess we could have been just friends instead. Tell me if I'm getting colder. I still see your face. I see on my shoulder. I still see on my shoulder. 'Cause all I am is getting older. I still see your face. I see on my shoulder. I still see on my shoulder. Suddenly you're nowhere to be found. I turn around and everything has changed. Looking for a way to work it out. I'm trying to find some peace to navigate. The oak tree where I met you and the writing on the statue. I still remember every word you said. I'm not a soldier, but I'm fighting. Can you hear me through the silence? I won't
Hello, everyone. I'm doing something totally different today. I never have streamed in the morning. First time I've ever done this. And I am streaming something that I'm doing for my work, my actual job that I do every day. I am teaching or presenting, I guess, a webinar for my law firm. Uh, Apparently, over 100 attorneys have registered to attend, so it will be interesting to see how many actually show up. And I'm going to stream it. I'm going to stream the whole presentation. I've got it going on Twitch, Kick, YouTube, and TikTok. So I'm interested to see how this goes. I think anyone who sticks around for this entire presentation will understand why I don't usually stream this kind of content. It's probably going to bore the hell out of most people that watch my e-date shows on Twitch. So this is not exactly crossover content, I would say. But it'll be interesting to see what happens, and I want to see if I could do some sort of legal streaming in the future as well. So we'll see. The topic that I'm covering today is a topic that I'm an expert in, but it's a very niche subject within patent law. It deals with subject matter eligibility of patents. And I'm going to go through the U.S. Patent Office guidance pertaining to this topic, and also cover some of the case law and describe an instance that I worked on at my law firm related to this recently. All the attorneys who are going to attend today get credit for their continuing legal education, at least in certain states. I think California, Texas, and a couple of others. Minneapolis is another one. Minnesota, I mean. So I am going to be joined soon by a person in the marketing department of my firm who is going to help me make sure that everything is configured and ready to go for the presentation. We are starting the presentation in about 30 minutes, so we're going to prepare and make sure everything's working before that. I have my slide deck up, and let's see. I've got a couple of views of the slide deck just in case I need to show the edit mode or the playback mode. Hello?
Hello, how are you?
Good. Can you hear me?
Sure can.
Okay, good. Because I am streaming on Twitch, Kick, YouTube, and TikTok right now.
Wow, awesome.
I have 5 viewers on Twitch, and it looks like 2 viewers on Kick. And I don't know about the other platforms. So we're just, they know that the presentation isn't starting for another 30 minutes or so.
Wow, great.
But
Hello, everybody.
let's see. I wanted to see how to make sure that I could share the slides here. That's the first thing we should make sure is working, right? Okay, let me turn up the audio first of all a little bit here if I can. Oops, that's not the right thing. Let's see, which I want to share the screen. Here it is. I think this is it. All right. That's not showing the right screen, right? It's not showing the slides? Or can you see the slides?
It's kind of the PowerPoint view.
Oh, okay. Wait, if I click this, okay. Is that it?
It's better. It's kind of showing there's a big dark space above the top and at the bottom. But
Oh. Huh. Okay, let's see. I'm going to exit out of that view. Let me stop sharing in Zoom for a second here. I wonder if I need to condense it down on my screen or something so that it gets rid of the top. Does it look better in this view the way it is now?
I'm not seeing it quite
Oh,
yet.
hold on. Let me share it. Sorry. Um, okay, so that's one view that I can show.
Yeah, so there's a PowerPoint.
If I go through the slides, does it look good or no?
It was better the other way.
Really? Okay. Even though there's a
Yeah,
big space.
yeah, because this way, so this is showing the PowerPoint view. So it's kind of like you're in PowerPoint,
Yep.
and then this way, is there a way, can you can you maximize your screen? Because the screen is kind of showing um, just in the middle portion
How
of my
about
screen.
how about this? Oops. Did that help or no?
Still, this is better. This is better for sure. You might be able to maximize it still a little bit vertically, but now it's taking up the whole way horizontally.
You want it? Okay, let's see. How's this?
It was better before. Now it's showing a little bit of dark space on the left and right.
Okay. How's this?
That's the best one so far. There's still some kind of blank space above the PowerPoint screen.
Huh, that's so weird because I've on my screen it's totally filling the entire window.
But this is still pretty good. If you
Okay. That'll work. Okay, I'll try to keep it like this. I've got to fix something here on my side as well. I have some people asking about what I'm doing here. I am preparing to give a presentation to a bunch of attorneys regarding this subject matter here that's on the slides. And this is Michelle at my law firm, whose voice you hear.
Oh.
We are getting it so that it will look better on the Zoom presentation.
So in the upper right-hand corner of the PowerPoint, there's kind of that rectangle symbol. Does it let you click on that to still maximize it?
I don't want to do that because I need access to my screen.
Oh, okay. Yeah, this is the best one so far. And so this one, what I'm looking at now, it takes up the whole thing horizontally. There's just some kind of dark space.
I could
There on my screen, at least there's maybe 2 inches of dark space above it. But let's see. And so now there's a little bit of dark space on the left and right. So
yes, I'm seeing that for sure. But I'm not seeing the
Yeah.
dark space. When I put it here, I don't see the dark space above or below. I see it totally centered.
and this one is the best one so far. And it
Okay.
it could just be my screen too.
Okay, and hopefully it's good enough for the people to see. Okay, now I need to fix one other thing on my side to make sure it's displaying here as well. Okay. Hi, Vivnus. Okay, thank you for tuning in. Handful, I see you there too. Thornhorn, the theme of the stream is recent developments in subject matter eligibility guidance and case law. The audience that I have here, Michelle, is not a patent attorney audience, so they're going to be asking some interesting questions here, I think.
Sure.
Okay, let's see. To get this up on the screen here. What do I need to do? Okay, here we go. Wonder why I can't get it to show on my side. I want to get the slides up so you in my stream could see it as well. So that's what I'm trying to fix right now. Oh, I think I know what the issue is. Okay, I think I can fix this. Here we go. There we go. It's coming up on my side as well now. All right, those are the slides. Let's see if I can center this a little bit better. Okay, I think I've got it up. Now I've got to center it a little bit more on my screen. All right. Still looks good on your side too, Michelle?
Yep.
Okay, good. The Thornhorn, you want to know what is an attorney? A lawyer of some sort, says Vivnus. Yes, that's right. I am an attorney, and I specialize in patent law. And this is my law firm, SLW, you see in the slides, Schwegman, Lumberg, Worcester. And my job every day, I am working on getting patents for people. So that's what I do. What if they cannot handle the law? Well, the Thornhorn, I'm going to be helping people handle this law a little bit better today, hopefully. I am an expert in this particular subject matter. Maybe by the end of this, the Thornhorn, you'll want to go to law school. And I'm going to skip through a couple slides. Michelle, does it look right?
Yep.
Okay. How many people do we have registered now?
I have over 155 now.
155?
Yeah, that's really good. And probably, so usually about half of the registrants attend live.
Right. Yeah, that's what I thought. So it won't be a full
Yeah.
group.
Yeah, yep, absolutely. And lots of people will be watching the recording later, and we'll post it on LinkedIn, and we'll post clips on LinkedIn. So did I read somewhere? Oh, go ahead.
Oh, I was going to say, I don't think they're going to see me, right? They're only going to see the slides, unless I do something to add myself to it, which I don't know if I want to.
Well, so they'll see you unless you turn your camera off.
Oh, so they do see me.
Yep.
Okay, so I'm not seeing what they're seeing on your side. That's interesting.
Oh, do you not see the cameras?
I do see the camera, but I don't see how it looks on their screen. So I guess I see myself in the Zoom meeting, but I don't see how it looks with the slides on the screen as well.
Yeah, and I think they can just move. They'll be able to move the cameras around.
I see.
On the screen.
Okay. And so they see my virtual background then, with my office.
Yep, yeah.
Okay. My fake office in the background. Okay. Let's see. There's something else I wanted to fix here. Okay, hold on. You've done land title work before, Thorn? So you don't want to be a lawyer because of that? Okay. That's physical property. I deal with intellectual property, so it's a little bit different. Okay, it looks like we're still 19 minutes away from the start of the presentation. And then, Michelle, you'll like introduce everything, and then I'll start after that.
Yeah, yep. So what'll happen? So I have a start button on my end, and so in 19 minutes I'll hit the start button on my end, you'll see something will kind of go up on the screen about how it's being recorded because it is being recorded. And then I'll say hello and then I'll wait for at least 10 seconds because there'll be kind of a lag while it lets people join.
Mm-hmm.
Yeah, so don't worry anybody if you hear me say hello and then there's this big long pause
Right.
because we're just letting people join, and then I will welcome people, and then I'll just let people know that we're recording it, and we'll be sending out a link to the slides to everybody who's registered in the Zoom webinar, and then I'll say that our speaker will be Kurt, and I'll say a few words about you, and then I will hand it over to you.
Okay, and during the presentation, will you be able to see if people are asking questions? I'm not sure I'm going to be able to see it when I'm in presentation mode.
Sure, yeah. So if you kind of wiggle your mouse a little bit, there should be that Zoom menu that pops up. And then there's the chat. People might put their questions into the chat. There's also the more option. And then under more, there's a Q&A.
I'm not seeing these because in the slideshow view, all I see are some icons in the lower right corner, and none of them seem to indicate a chat or anything like that.
Oh, okay. So there is there a bar that has audio and video?
Oh, okay. Now I see there's a different pop-out window. Okay, so let's see if I can find it here. Okay. I do see the video, but it's only video, unless there's something here. Hold on. View profile. Okay, chat. There it is. Okay, I can pop out the chat. Good, I got it now.
Awesome. And there should be, and it may be under more. It looks like they kind of changed stuff in Zoom where they put the Q&A under a more option, but it lets you drag options from the more menu and move them onto the main menu.
Interesting. Okay. Well, I see the webinar chat. I think that's all I need. I hope.
And sometimes people might put their questions into the Q&A. If you want, I can keep an eye on that too.
Okay, I think I can watch the webinar chat. Is there another place where they could be submitting questions?
Yeah, there'll be a Q&A feature.
Huh. So there is something else here. I'm not seeing that here.
It might be. Does it have an option that says more?
No, but I see 3 dots.
Yep, I bet that's it. Does it have 3 dots and then there's kind of a circle?
No. So I'm looking at the video pop-out, which shows you and me in the video. And then when I click the 3 dots, I see view profile, chat, pin. Oh, okay, hold on. It was because there's 3 dots for you and for me. There's 2 different places. Okay. So now I see some other stuff here. But it's only profile-related stuff. Like, it's view my profile, mute my audio, stop my video, that kind of stuff. For the dots next to my video.
Okay. Are there options for react or share?
No, I'm not seeing that.
Okay, I could just let you know too. If it looks like
Okay.
there's questions in the Q&A, then, even at the end.
Yeah. Sounds good. All right, Thorne, thanks for keeping me in the background. This is not going to be the normal content that I have on my stream.
Oh, what do you usually have on your stream?
Uh-oh, I'm going to have to tell you. Yeah, this is kind of interesting because I'm merging my professional life with my hobbies and things here with this presentation. I host an e-date show on Twitch.
Oh, fun.
Yeah. So most of my audience is part of that show. Or they view or they participate on that show.
Oh, sure. Yeah. Sometimes the other people in the office talk about that show, Love is Blind. I've never seen it, but they like to talk about it.
Yes, I love that show. I like a lot of reality dating shows. And now I'm actually producing one on my Twitch.
Oh, wow.
Yep. I do it on Saturday night, so I hardly ever stream during the week or in the morning. So my viewers are not as high as they normally would be at this point.
Oh, sure. Yeah, my one of my brothers and his wife met online, and they've been married for how long now? For it must be well over 15 years, maybe 20.
Hmm. Yep, it can work. I've made some love connections. Yeah, Twitch is not really a dating site, so it's it does allow people to present dating type content though. So that's what I'm doing with my stream.
Oh, sure.
Yeah.
Oh, I read in your bio. So don't you run and um do horse racing or something too?
I recently kind of retired from horse jumping, but I was doing it for quite some time because it was part of modern pentathlon, and I run a nonprofit that helps people train for that sport. And so I was doing, I was coaching, and I was also participating in horse jumping for a while. Yep.
Oh wow. On LinkedIn, I follow some of those horse jumping competitions in
Oh,
Europe,
yep.
and they have the most beautiful pictures. I don't know very much about it. Even the exact names of the competitions or anything like that, but they show all these just gorgeous pictures of these beautiful horses doing those horse jumping
Mm-hmm.
competitions where they're in the stadium, and they they ride the horse around and jump over all the obstacles and also try to make a certain time.
Yep, that's exactly what I did, and I even competed internationally at one point. Um, I think it was 29. Oh wait, it was 2022. I think it was. I made Team USA and competed internationally in one event in modern pentathlon. It was actually Dominican Republic where I competed, and I jumped the highest that I've ever jumped, which was 3 feet fences at the time. It was very exciting, very interesting.
For sure. Yeah, I love those horses because when I was little, I don't know how to pronounce it, but I had those Breyer horses or Breyer. I don't know how to pronounce it, but those horse models.
Oh, okay.
Yeah, it's these kind of horse models that they look like real horses, and they're so beautiful. And then I love watching those photographs of the horses in the horse jumping competition because it looks just like them.
Mm-hmm. Oh, interesting. Yeah, the sport of modern pentathlon is actually a very exciting Olympic sport, in my opinion. And coming up for the LA 2028 Games, I have people that I'm training right now that are trying to make the Olympic team, and I'm
Wow.
coaching them. Unfortunately, horse jumping is no longer part of modern pentathlon. They made a big
Oh,
change, and they replaced it a few years ago. So the last Olympics was the last time you will ever see horse jumping as part of modern pentathlon. It's still part of the Olympic program, though, so it's a separate event. But they've
what?
replaced it with obstacle course racing.
Oh, wow. So is that still people jumping over the obstacles,
Yes,
or is it?
basically it's people
Okay.
now instead of horses. Yeah. You know American Ninja Warrior, the show?
I don't know if I've ever seen that.
Oh, okay. Well, it's an event where people race over obstacles, and they do things like monkey bars, rope swing, uh, this thing called the salmon ladder. There's all kinds of different obstacles that they do. Oh, and the warp wall. Yeah, I don't know if you've heard of that, but the warp wall, it's just a ramp that you run up, and it's very high in some cases.
Oh, wow.
So that's the new sport. It's been replaced. That's replaced horse jumping. There's 5 sports in modern pentathlon, by the way. That's just one of the sports that's been replaced.
Oh, wow.
Yeah.
It kind of reminds me of, I remember when I was in school, after we would come home from school, there would be those shows, after school TV shows or on Nickelodeon where the kids would do all that kind of stuff, and then there'd be slime.
Oh yes, exactly. Yep. Well, the other sports are running, swimming, fencing, and what am I forgetting? Oh, shooting. So laser pistol shooting is the other one.
Oh, wow.
Yep.
Do you remember maybe it was last Summer Olympics, there was that one guy who was in all the memes because when he would shoot, he just looked like just a regular guy because he'd have one hand in his pocket and then he'd just kind of go like this, and he just kind of like a dad that got off the
Yep.
couch.
That was
Do you
so funny. That guy, he was shooting a 10-meter air pistol. And in modern pentathlon, we shoot a 10-meter laser pistol. So it's very similar what he was doing to what we do. I thought that was cool. Yeah, that was really cool.
What's a laser pistol? Does it just not shoot like bullets?
Right.
It shoots.
It simulates shooting a real pistol. So it's just, and it shoots just a laser beam at a target that can detect where your laser beam hits. And so it's just simulating real shooting with in a safe way, right? It's like a laser pointer. It's still somewhat dangerous because you can't point it at your eye, but otherwise it's fine. Yeah. So
yeah, I can kind of see. I love horses, but I can kind of see why they would take the horses out because it probably makes it more accessible
yes.
for more.
Yeah, and modern pentathlon is probably the least popular or least well known of all the Olympic sports that are done during the summer program. And so they're trying to change it as much as possible to make it so more people can do it. And that horse jumping, it was hard for me to learn that. It took me 4 years, basically, and I had to find a barn and get people that would allow me to do it. And it was difficult. Like, it's a big barrier for people to enter the sport if you have to do horse jumping. So I think it's going to help a lot. There's a lot of ninja gyms around that people can train in. So hopefully it's going to bring more people into the sport. We'll see.
Oh, yeah, for sure.
Hi, Preg Pro and MRJ. Good to see you guys. Looks like I have 8 viewers now on Twitch. We are going to start the presentation in about 7 minutes. I've got it up on the screen already. Hi, Izzy. This is going to be some different content, guys. I don't know if you're going to like this content. I'm presenting to attorneys, by the way. You're going to love it. Okay, Preg Pro's not going to like it. He's going to love it. Okay. Well, I'll ask you at the end if you loved it. No, I haven't started yet, MRJ. I'm talking to Michelle, who's one of the people on the marketing team at my law firm.
Hello.
She's helping, she's going to introduce it, and she helped me prepare the slides, and we kind of planned this out ahead of time. And she helped, obviously, get the people to know about it and register for it. So we have 155 people registered. Not loving a Coach Kurt stream. You got to be out of your mind, says Izzy. Well, let's see, guys. This is going to be a test of your patience. It's going to be a test of my audience's patience to go through a law firm presentation, a webinar. MRJ, I'll quiz you at the end if you really want me to. At the end, I'll stay on the stream for a little bit longer so you guys can ask some questions if you want. Yeah, I know, MRJ. That's what I was going to say. You're going to be asleep, probably. This is the kind of content that will put you to sleep, I think. It's probably one of the most dry topics you could imagine. Oh, Handful, you're almost done with your stream? 24-hour stream? All right, looks like we're 5 minutes away. The countdown has started.
Yep, and when it's closer to time, so in 5 minutes, I'll just count it down. I'll say 3, 2, 1, and then I'll hit a button that I have on my end that says Start Webinar.
Okay.
And we'll be live.
Sounds good.
And then at the end, when I can tell that it's over, then I will just hit end, and that'll be that.
Sounds good. Will there be a way to know how many people are watching as it's happening in the Zoom? Oh, okay.
Yeah, there should be. So at least on my end, when I move my mouse around, so at least on my end, there's a bar that says audio and video, and then there's a place that says participants.
Okay, I'm not seeing it, but it's probably because of the view that I'm in. I'm not sure. That's okay. I don't need to know. I'd rather not know. It's going to make me more nervous if I know how many people are watching.
And afterwards, I can send you the reports and stuff.
Yes, I'll be curious to see. I think last time when I did one of these presentations, we had over 200 people registered, but only I think 70 or something came, or something like that. So it's probably going to be half or less.
Yeah, and that's pretty normal. You know, people sign up and then meetings come up or work comes up or kids or something and
Handful Army
people
I
start
just raided
recording
with
too.
7 viewers.
Handful, thank you for your 7-viewer raid. Congratulations on your 24-hour stream. I'm going to shout out Handful Army Guy. You brought your viewers to the most dry content they could imagine. I'm going to see if anyone even stays around for this. But I'm at 19 viewers on Twitch now. Okay. All right, we're adding the 19 viewers on Twitch to the 150 registered attorneys that are going to be here.
Well, there's, even just on Zoom, there's over 25 people in the waiting room.
Oh, wow. Okay, so there's 25 people just waiting to be let into this exciting presentation, guys.
They are. They're lined up outside, and then in a few minutes, I'll hit start and we can let them in.
All right, we count down 2 minutes. Now I'm getting a little nervous, guys.
No need to be nervous. This will go great.
Okay. I did give this presentation once already, so we'll see. No, I don't have a drink with me, Izzy. Just water today. Got my hint water. Oh, okay. One of my viewers wants me to hire you as my producer, Michelle.
I kind of felt like a producer. I feel like Roz on Frasier.
Yeah, you guys are going to see. She's going to do an amazing introduction.
Oh my. Pressure's on now.
Yeah. Izzy, you think I'm nervous? Yeah, just relax. Okay, I'm going to try. These are attorneys I'm going to be talking to. It's a lot different. All right, 1 minute. Less than a minute.
Now there's almost 40 people waiting to get
Okay,
in.
40 people. Wow. That's going to bring our total viewership to almost 100 across all the platforms. You were made for this moment. Okay, Frank Pro. I should be more animated, MRJ? I don't know. No, not for this audience.
Okay, so I'm going to count it down 3, 2, 1, and then I'll hit start, and then we'll be live.
All right.
All right, here we go. 3, 2, 1. Hello, welcome. Hello, and thank you for joining us for the SLW Institute webinar, Recent Developments in Subject Matter Eligibility, Guidance, and Case Law. We will be recording the webinar today and sending a link to the recording and slides to everyone who has registered. We will also put a link into the chat to where the presentation slides are posted online. If you would like to ask a question, you can enter questions using the Q&A feature in the Zoom menu or in the chat. Our speaker today will be Kurt Iverson. Kurt is an intellectual property attorney and principal at SLW. He is a registered patent attorney with more than 15 years of experience. His education includes an MBA and a Master of Science in Engineering from San Jose State University and a law degree from Santa Clara University School of Law. And with that, I'll turn things over to Kurt.
Hello, everyone. I'm working in the Silicon Valley office of Schwegman, Lumberg, and Wussner. I've been working here since I graduated from law school at Santa Clara University. As you might imagine, a lot of my clients are software clients, and my expertise is in software. And subject matter eligibility is a big concern for a lot of my clients. And so I've become one of Schwegman's experts in this particular area of the law. What I'm going to do today is cover some of the recent developments in subject matter eligibility guidance and case law. I'm covering basically since the 2024 AI SME update, for the guidance at least. And for the case law, I'm going to go back about as far as Berkheimer. If you want interesting subject matter covered related to this, I have 2 other webinars that are posted on the SLW Institute that go back further. But this is more of what's happened recently. Just as an overview, the USPTO has issued guidance updates, 3 of them, since the 2024 AI SME update. By the way, the 2024 AI SME update was effective July 17, 2024. So these are memos that were released since then. The August 4 memo gives some reminders to examiners about what they're supposed to be doing when they examine a patent application with respect to subject matter eligibility. The December 4 memos, there's 2 of them, they talk about subject matter eligibility declarations, or otherwise known as SMEDs, and best practices for SMEDs. And then 1 day later, the December 5, 2025 memo covers the Desjardins case, and this is a very significant case in recent developments. As far as the CAFC case law updates since Berkheimer, which was February 8, 2018, there's 21 cases finding eligible subject matter and 39 cases finding ineligible subject matter. And we're going to just touch on a couple of these cases near the end of the presentation. Let's talk about the August 4 memo first. This memo purports to provide guidance on the following topics that arise when examiners assess Step 2A of the USPTO's subject matter eligibility analysis. Reliance on the mental process grouping, distinguishing claims that recite a judicial exception from claims that merely involve a judicial exception, analysis of the claim as a whole, and consideration of whether a claim is directed to an improvement in the functioning of a computer or any other technology or technical field. There are multiple steps that the examiners go through when they're examining a patent application to determine if it's eligible for patenting. And Step 2A has multiple prongs. Prong 1 is the prong where they determine whether an idea is included in one of the enumerated categories of abstract ideas, which are, one of them includes the mental process grouping. And prong 2 is where they determine whether, even if a claim is directed to one of those enumerated categories, whether it includes a practical application. Finally, there is another step to the analysis, Step 2B, where the examiner is supposed to reconsider again the claim as a whole to determine whether it might include significantly more than any alleged abstract idea that's included in the claim. So what this memo first tells the examiners is that the mental process grouping is not without limits. Now, as a practitioner in the field, I often find that the examiners are raising the mental process grouping as the category that the claim is directed to, and it's sometimes hard to escape that analysis. And I think what the office is doing here with the memo is basically telling the examiners to back off a little bit on their categorization of certain claims as being included in the mental process grouping. So I think if we go back really far into the case law, what was meant is, originally anyway, in the case law, is that you can't patent a thought that you have. That's what a mental, that's where the mental process grouping kind of stems from, I think, is that the idea originally was you cannot patent a thought that you have. And many of our claims go far beyond just something that you're thinking about. And even though there is case law, obviously, that covers other things besides just thoughts that are included in this grouping, I think what the Patent Office is saying is let's not categorize everything as being a mental process. Also, the memo mentions that examiners should be careful to distinguish claims that recite an exception from claims that merely involve an exception. And that's kind of interesting because that's a subjective determination, which as a patent attorney, I will be arguing that your claims just involve one of these exceptions. They don't actually recite the exception. Looking at step 2A, prong 1. Again, there's some examples given, and these examples are very important, I think, that are highlighted in the memo. With the subject matter eligibility guidance from the Patent Office, there are, I think, approximately 49 examples that demonstrate claims that are eligible for patenting or not eligible for patenting, and gives reasoning for how they were determined to be one or the other. And the memo highlights a particular example, which is very interesting. Example 39 of the examples that are included with the subject matter eligibility guidance. When the 2024 AI SME update came out, there was a question as to whether example 39 was still valid. This example 39 talks about training the neural network in a first stage using a first training set is one of the quoted elements in the memo. And what I find very interesting about the fact that they highlighted example 39 is they're basically saying this is an eligible claim still, even in view of the 2024 AI SME update, which gave other examples of types of machine learning that are eligible or not eligible. So they're highlighting this and they're saying that this particular element, training the neural network at a first stage using the first training set, is not abstract. And that's what the memo is reminding the examiners, and it's what's shown in the examples that come with the guidance. Now, this is where it gets very confusing, and this is part of why subject matter eligibility is such a huge problem with the way it's being done at the Patent Office today. There are about 80 pages of guidance in the MPEP, which is the Manual of Patent Examination Procedures, and those 80 pages just for subject matter eligibility. And so the examiners have a lot of difficulty understanding what they're supposed to be doing here. There's a lot of material for them to understand. And this example really highlights a problem with the way they're being trained, in my opinion. So you see example 39 just talks about training the neural network in a first stage using a first training set. That is not considered to be a mathematical concept. It's not considered to be directed to any of the enumerated categories. It's step 2A, prong 1, that particular element. Now contrast this with another example, claim 2 of example 47. This is what the memo is highlighting, by the way. Claim 2 of example 47 talks about training an algorithm using a backpropagation algorithm and a gradient descent algorithm. Now, as you can see, this contrasting example is far more specific with respect to the algorithms that are being used. Where we have example 39, we're just training the neural network in a first stage using a first training set. Here we have a very specific example of using certain algorithms that are recited in the claim. And this is where I just don't get the memo and why they highlighted these particular examples, because they're saying This far more specific recitation is a mathematical calculation and therefore not eligible, or at least directed to, one of the enumerated categories of ineligible or abstract ideas, particularly a mathematical calculation. So this is a very confusing part, and I just wish that the USPTO had not used these two examples because they're not giving a good argument, in my opinion. When we're talking about the claims, usually more specificity is better, and they're giving an opposite example here to that concept. Now we're going to look at what the memo says about step 2A, prong 2, and this is where we're looking for a practical application in the claim. So the memo tells the examiners, an important consideration in determining whether a claim improves technology or a technical field is the extent to which the claim covers a particular solution to a problem or a particular way to achieve a desired outcome, as opposed to merely claiming the idea. And again, the examiner is reminded to consult the specification to determine whether the disclosed invention improves technology or technical field. This is good, I think, because what we're finding with the case law, when we get to the CAFC cases, is that there must be a nexus between the claim language and the problem and the solution that's described in the specification. And that's one of the key ways to determine whether a claim is eligible for patenting or not. It's whether you've described with sufficient detail in the specification the technical solution to the technical problem, and you've claimed it, that particular, or claimed something that ties the claim language to that description that you have in the specification. So the memo's just basically reminding the examiners that's how we make the determination. That's how you determine whether there's a practical application or not. This is important language that I like to include in office action responses now. A lot of things can be quoted right out of this memo and used in office action responses when the examiner is rejecting a claim as allegedly failing step 2A, prong 2. One important thing is examiners are cautioned not to oversimplify claim limitations and expand the application of the apply it consideration. This goes way back because the Alice decision is where things started to get complicated. In 2014, I believe, was when the Alice decision came out. Before that, when I was a practitioner in my first couple of years as a patent attorney, all we had to do to overcome a 101 rejection was add a processor to the claims. In other words, we tied it to hardware. And if you performed steps using a processor, that was usually sufficient to establish eligibility. But since the Alice decision, what happened in that case was there was a claim that dealt with intermediated settlement, which was a well-known problem and had been handled manually in the past. And all the claim did was apply a computer to solving the intermediated settlement issue. And that is not sufficient now, as of Alice, to establish eligibility. So the memo is basically telling the examiners, again, to back off a little bit on the claims and whether you're oversimplifying the claim limitations or not. Because what has happened since Alice, we had a claim that recited intermediated settlement applied on a computer. But now that same case is being used to reject claims that are way more specific, that do far more than just recite an abstract idea and apply it on a computer. So the memo is just telling examiners, kind of reminding them, I guess, that we can't oversimplify the claim limitations. This is very important language from the August 4 memo that I'm using in all my office action responses now. Examiners are reminded that if it is a close call as to whether a claim is eligible, they should only make a rejection when it is more likely than not that the claim is ineligible. I don't know if it's going to help much, but I'm using this in every response that I do. I'm arguing that we have a close call, and therefore there should not be a rejection raised. So this memo helps us a little bit. let's get to the December 4 memos. There's 2 of them. The first one talks about subject matter eligibility declarations. And this is very interesting because you might know of certain cases, or I don't know how many of you encounter this or software experts, but the examiners are almost always raising, if you end up in certain art units, let's say 3600, they're raising a subject matter eligibility rejection, and they're often sticking to it to the point where you cannot overcome through multiple rounds of prosecution, even with examiner interviews. You cannot persuade the examiner to withdraw the rejection. This gives an option that has not been, I've personally not used it yet, but I know some of my colleagues have started to investigate this, and we've started to, I think 1 or 2 clients of ours have actually filed these. They're memos where you can have an expert basically sign an affidavit saying that there is an improvement here that goes beyond the abstract idea, or that you have something significantly more than an abstract idea. And this may be a way, I think the Patent Office is reminding examiners that there's a way to use evidence to show that you have something that's eligible for patenting. And so they've issued this memo to just tell the examiners, look, there is a route that certain people may choose to take to establish evidence that their idea is eligible for patenting. People who can file these, any person who has knowledge of the facts being asserted in the declaration may sign the declaration. So an inventor, a co-worker of the inventor, an independent expert, these are examples of people who could sign an affidavit, and you could file this as evidence in support of your claim being eligible for patenting. So no special qualification other than knowledge of the facts is required. This is very interesting. Again, there's some guidance in the memo about what is sufficient for establishing evidence. And again, there must be a nexus between the invention as claimed and the evidence provided. And there's an example of a SMED may demonstrate how one of ordinary skill in the art would interpret a specification to show that the claimed invention is eligible. And to be a probative value, any objective evidence should be supported by actual proof. So this is just some of the requirements for a SMED. This is a very interesting point raised in the memo, which may or may not be accurate, actually. It says the specification need not explicitly set forth the improvement, so long as the specification describes the invention such that the improvement would be apparent to one of ordinary skill in the art. I think the standard is higher at the Federal Circuit. If you look at some of the recent case law, the court is looking at the specification to see if the actual solution and problem are being described sufficiently, and then checking the claims to see that the claims correspond or are tied to that description. Interesting that the memo kind of makes that a softer requirement here. The memo makes clear that the examiner must carefully consider all of the applicant's arguments and the evidence rebutting the subject matter eligibility rejection when evaluating the applicant's response. So the office is telling the examiners that they have to take these SMEDs seriously. If you have someone sign an affidavit that establishes that an expert thinks that this material is eligible for patenting, the examiner must consider that as evidence and must take it seriously. This is a great, I think, option potentially for those difficult cases where the examiner just is not backing off on the subject matter eligibility rejection. Before I get to this next part, there's a second memo. It's the best practices memo. And there's not much to this memo, actually. But I think one of my colleagues raised an interesting point, and that's that with these SMEDs, you also have to be very careful about estoppel. You don't want to concede, or you don't want to establish or put in the record that a claim is more narrow than it actually is in its recitation. So the way that the affidavit is made has to be done very carefully, I think. to make sure you're not narrowing the subject matter through prosecution history estoppel. And so I would look, if you plan to do one of these SMEDs, there are some examples at the end of the first December 4 memo that show very specifically types of affidavits that work in certain cases. And so it's worth looking very closely at that memo at the end, especially those examples, to figure out what makes the most sense in your particular case. And you should be conscious of the estoppel issues that can arise. You don't want to characterize your claims as being narrower than they are. That's really one of the most important things to look at when you're doing a SMED. Now, this second memo, same day as the first memo regarding SMEDs, all this memo does is repeat a lot of the material from the first memo, and I actually took out the quotes that are used in this second memo and highlighted in the second memo. We've already gone over those now. But what it's telling here in this second memo is telling people that file a SMED to file them separately from any other declarations. That's all this is. The best practices memo is basically saying when you file a SMED, make it a separate filing. They give some reasons for this. Ensures clarity and relevance of the evidentiary record, facilitates examiner review and decision-making, enhances the clarity and may bolster probative value of the SMED, and reduces risk of procedural or substantive confusion. You know that is a big problem with the 101 rejections right now, is examiners are conflating the 102 and 103 issues with the 101 issue. And the problem is, even back to the Alice decision, there was some conflating of these issues. 102 is whether a claim is anticipated or not by the prior art, and 103 is whether the claim is obvious in view of the prior art. So obviousness and anticipation are being mixed often into the 101 rejection, which is supposed to be just about eligibility of the subject matter, not whether the prior art teaches or suggests the elements. So they're trying to, I guess, make the point here that when you're talking about subject matter eligibility, let's not mix it with the other issues that are related to patentability. So that covers the December 4 memos. The timing of these memos is very interesting. The next day, the Patent Office released the December 5 memo. Now, the December 5 memo talks about the Desjardins case. And the Desjardins case was a very interesting and strange case. What happened was the commissioner for the Patent Office established a review by appeals board. It's called an ARP, and he is the only one who can make this appeals board. And he created this appeals board to review this one particular case and to reverse the appeal board with respect to this case. This case had to do with a software claim that was found to be ineligible by the appeal board, and the commissioner had it reversed by the ARP, the Appeals Review Panel. So there's some interesting things in this memo that I think help people that are seeking a software patent, potentially. And the memo goes over changes to the MPEP that have been made since the case in view of this reversal of the appeal board. Here's one of the paragraphs that is going to change in the MPEP after the Desjardins decision. I think we don't have to look specifically at the Desjardins decision because this is what the examiners are being taught in view of the Desjardins decision, and this is what we need to be aware of, I think, as far as what the examiners are being told. So this is a precedential decision. The claimed invention was a method of training a machine learning model on a series of tasks. By the way, this brings up an interesting point with the new direction that the Patent Office is taking with respect to AI. It started with the 2024 AI SME update. They want to make it easier for people to get patents on AI-related technology so that the U.S. can be competitive in this space. Obviously, if the examiners are rejecting AI-related inventions under the 101 statute, we are going to lose out on potentially a lot of patents that could be and should be determined to be eligible. So I think that's part of what this what this series of memos is dealing with here. So let's look particularly at what was talked about, what's being changed in the MPEP here. So the appeals review panel upheld the step 2A prong 1 finding that the claims recited an abstract idea. In other words, it was included in the mathematical concepts, which is an abstract idea. But at prong 2, the ARP determined that the specification identified improvements as to how the machine learning model itself operates, including training a machine learning model to learn new tasks while protecting knowledge about previous tasks to overcome the problem of catastrophic forgetting encountered in continual learning systems. So I think this is laying the groundwork for how an examiner is supposed to look at the cases. They're supposed to look at the specification. Let's see what the problem and the solution are that are being described, and then look to the claims to see if the limitations reflect that improvement that's described in the spec. So that's what is being changed in the MPEP. It's already been in the case law for quite some time, but this is just something that, again, the examiners are being told that they are supposed to be doing when they analyze a case or a claim to see if it's eligible for patenting. There are some additional sections. I know this is a big block of text here, but there's additional sections in the MPEP that are being changed. It's basically explaining why the ARP overturned the appeal board with respect to this decision in Desjardins to find eligible subject matter, and trying to explain to the examiners, here are some of the things that caused us to determine that the board was wrong in rejecting this claim. So with this information, the examiners should be changing their procedures slightly and looking at especially AI-related inventions as being potentially eligible rather than ineligible. They are presumed to be ineligible by many art units right now, in my opinion, 3600 being an example. And I think that these memos are meant to kind of change the view of some of these examiners and some of these art units. Again, there's just another modification to the MPEP here to add the ex parte Desjardins case to the list of cases that support improvements to technology or a technical field. Now, I think it talks specifically about the technology, including data structure elements, reciting adjustments and values to a plurality of performance parameters, while preserving prior values. So this is just like some specific information about the actual claim language that was found to be eligible for patenting. These are other sections that are revised, and you can look at these slides later. I don't want to go into too much detail here, but I did cover the most important sections, I think, that were changed in the MPEP as a result of the ARP overturning the appeal board in the Desjardins case. Again, it's a machine learning, training of a machine learning model considered to be eligible for patenting. Okay. The next part of the presentation, I'm going to briefly go over some of the case law updates since Berkheimer. If there are any questions about the memos, you could put those in here in the chat as well, and I could try to get to those. So since Berkheimer, this is 2019, there are 39 cases finding ineligibility and 21 cases finding eligibility. Now, of those cases that were found eligibility, only 16 pertain to software. Now, of those 16, 11 were found to be not abstract, and 5 were found to be have an inventive concept. This is very interesting data. First of all, it shows what you're up against. If you take a case to the Federal Circuit, you're probably going to lose more than half of those cases. Also, something I find to be very interesting about these statistics, the decision of whether the claim was eligible or not was made at step 1 in 2/3 of the cases. And that is contrary to what you will find when you're filing a patent application and having an examiner review it. Examiners will almost always find at step 2A, prong 1, that your claim is directed to one of the abstract concepts. That the only chance, usually, when you're prosecuting an application with an examiner at the patent office, is to succeed at the second step. In other words, you need to show a improvement, basically a practical application at step 2A, prong 2, or that you have something significantly more than the alleged abstract idea at step 2B. Now, if that's the case, we have the patent office dealing with the claims in a certain way that's slightly different than what the Federal Circuit is doing. Unfortunately, that leaves us with only 5 cases that are helpful out of all the cases that have been decided since Berkheimer. This is a problem because the examiners are obviously finding too many cases to be directed to one of the enumerated categories of abstract ideas at step 2A, prong 1, and it's almost impossible for a practitioner to persuade them otherwise. And that's different than what the Federal Circuit is doing here. The Federal Circuit is finding eligibility at the first step most of the time. I have a list of cases here, and I think it's important to go through them. So these are the cases where claims were found to be eligible since Berkheimer, and it covers at which step they were found to be eligible and what the technology related to. So I think this is important to look at. Atrix is the first one on the list here. Here's where an inventive concept was found, even though the claims were directed to an alleged abstract idea, and this related to importing data into forms. So here's a great example of a software application revolving around importing data into forms, and there was an inventive concept found. That's good. That's good news for people that are seeking software patents. Now let's look at things that were found to be not abstract. A tab interface for 3D spreadsheets. That's just simply not abstract. Software licensing, software license control using a BIOS. Now that makes more sense to me that it's not abstract. We're dealing with a BIOS. It's a low-level operating system. SRI International found evaluating network data to find suspicious activity to be not abstract. That's important because there are many cases that I deal with that involve network data, security type related software inventions, and this is a good sign that this was found to be not abstract by the Federal Circuit. Self-spin, data transfer between devices, inventive concept found. This is where it's so important to describe what it is that you're solving as far as a technical solution to a technical problem in the spec and tying it to the claim language. It just shows that you can get a claim still today on data transfer between devices. More that were not abstract. Error checking in data. Cardiac monitoring device makes a lot of sense that would not be abstract. Communication station, not abstract. These are kind of physical devices. Okay, identifying disjointed network connection flow, not abstract. Improved lab technique for sorting particles, not abstract. Encryption method that improved network security, not abstract. Authenticating users at a terminal. This was found to have an inventive concept, and we're going to go into this case in a little more detail. Peer-to-peer file sharing. Inventive concept found. Recording physical movements and using data for electronic searches. Inventive concept found. Encoding serial number in an RFID chip. Not abstract. Cameras that streamed low quality image stream for live camera control. Not abstract. And then this last one, polycrystalline diamond compacts. claimed with limitations relating to magnetic properties. That's obviously not abstract. And then finally, I just put the Desjardins decision here because it was considered to be an important case. And it's a method for training a machine learning model, not abstract. Now, these are all the cases that we have since Berkheimer that can help us with an examiner rejection. Now, again, the problem is that the examiners are never, almost never, backing off from the prong 1 analysis, a step 2A prong 1, where they find a claim to be abstract, and leaving us to only argue that we have a practical application. So there's only those 5 cases where an inventive concept was found that are helpful. I asked ChatGPT to look at these cases and figure out what do the non-abstract cases have in common. And this is what I got. Of course, you have to take everything that ChatGPT says with a grain of salt, but this is what it said. They each specify a particular mechanism, structure, or technique rather than a desired outcome. They each operate on or within the technology itself rather than using technology as a tool for a non-technological task. They each respond to a limitation that is specific to the technology, and none of them are primarily characterized as collecting, analyzing, and displaying data. That's an important one because this always comes up, and it's a problem with software inventions in particular because the claims often involve collecting, analyzing, and displaying data. Now, as a patent attorney, I've started to modify the way that I draft the claims to not simply specify collecting, analyzing, displaying data, but to go further. But it's tricky because this is a problem with many of the cases that are found to be ineligible, is the order of the steps tends to be this for a lot of different software applications. Now, here's the more important one, because this is where we are more likely to be able to persuade the examiner that we have an eligible application. And it's at step 2A, prong 2, where we're trying to show the inventive concept. So I asked ChatGPT, what do the cases found to have an inventive concept have in common? The inventive concept resided in a non-conventional arrangement or combination of known elements, rather than in a single novel component, so that's interesting. The claimed combination provided a technical benefit distinguishable from the abstract idea. The inventive concept was tied to specific claim limitations rather than unclaimed specification disclosures. And the cases, this is not relevant to us though, the cases frequently arose at the Rule 12 stage, where factual questions about conventionality remained open. This is usually not an issue for us, but we do have the SMEDs now. So the SMEDs are a way to establish evidence, but it's not a Rule 12 stage because this would happen during litigation. But this is just an interesting encapsulation of what we have to work with here when we're talking to an examiner in view of the case law, and we're dealing with step 2A, prong 2, which is trying to show a practical application. Now I'm going to get into some specific cases, and one that's related to a case that I was recently dealing with for a client. We're going to look at a patent eligible case here. This is the actual claim of the Ancora case. And the Ancora case talked about a method of restricting software operation within a license in a memory area of a BIOS of a computer. And these are the steps that were found to be eligible and actually not even abstract, just this eligible, and decided at step 2A, prong 1 is not abstract. So the steps are pretty basic. Selecting a program residing in memory. Using an agent to set up a verification structure in the erasable non-volatile memory. Verifying the program using at least one verification structure. Acting on the program according to the verification. That is considered to be a not abstract claim. And that to me is crazy that this is not even considered to be abstract. So, at step 1, the court found the claims were not directed to an abstract idea. The invention related to operating software within the limits of a software license. Let's see. So they found that the case focused on a solution to a computer functionality problem. The proposed technique departed from earlier approaches, which, when you look at that claim, I am surprised that they thought that. Okay, and because the claims were found to be patent eligible at step 1, not directed to an abstract idea, the court did not evaluate step 2. There was no reason to even check to see if there was a practical application because the court determined this is not abstract. They related it to Enfish and McRow, which are two favorable cases. Now let's look at Universal Secure Registry. This is another one of the cases that was found, this case I think was found to be ineligible, and it's important to distinguish it from the other ones. Okay, so at step 1, the court determined that this particular code-related software application was related to a known abstract concept. They dealt with, this is during litigation, so they dealt with the patent owner's counter-argument that this particular element of time-varying multi-character code was a specific technique. Here's what the claim looked like. This is the actual claim. So the claim related to providing information to a provider to enable transactions between the provider and entities who have secure data stored in a secure registry. The steps involved a receiving step, a mapping step, a determining step, an accessing step, a providing step, and an enabling step. The court looked to see whether there was a practical application and determined that there was not one. They viewed it as similar to Alice, which is where the intermediary in Alice facilitated settlement between parties, and they compared the code of the claim as being analogous to that case. So the one-time code was performing the same type of function, mediating a transaction, and therefore could not rescue the claim. So we've got one that's eligible, which used much broader language, in my opinion, and one that's ineligible that had very specific language around the types of data that were used and the one-time code and various other factors that related to this. Now we're getting to a third case, and this is where we find an eligible case, which deals with almost the exact same subject matter as the previous case. So here we have a method of authenticating a user to a transaction at a terminal, and the steps involve transmitting a user identification, providing an authentication step. As a criterion to deciding whether to authenticate the transaction, having a device check whether a predetermined time relation exists, ensuring the authentication function is normally inactive and is activated by the user only preliminarily, ensuring that the response includes information that the function is active, and thereafter ensuring that the authentication function is automatically deactivated. So this case also dealt with a security transaction at a terminal, just like the previous case. The language is more broad than the previous case, but the court found this one to be eligible for patenting. So this is where all the confusion with 101 stems. For examiners and practitioners, is these cases are almost indistinguishable from each other, in my opinion, and one is found eligible, the other is not eligible for patenting. And in fact, I would say they got the opposite answer of what they should have come to. But again, it comes down to the facts, the very specific facts of what is included in the specification versus what is claimed. And often if you've described in the specification the technological problem and the technological solution clearly, and then your claims tie back to that, the claim should be found eligible for patenting. And that may be why you see a much broader claim here being found to be eligible for patenting versus a narrower claim being found ineligible for patenting. So in particular, here's where the courts came to the answer at step 1 that the claim that we just looked at was not abstract. They didn't even look at the second step because they just determined this claim is not abstract. So this is the mess we're in right now with all the different case law, the guidance, and all this inconsistent decisions that we're dealing with. And you even have the judge in this case saying the court made a mistake by not looking at step two. Step prong. Okay, there's also something else we need to clarify here. The guidance does not align exactly with the Federal Circuit case law. Step 2A, prong 1, is whether something is directed to one of the enumerated categories of abstract ideas according to the Patent Office. That aligns with Mayo Step 1, Alice Mayo Step 1, that the Federal Circuit is using, where they make the same kind of determination. Now, Step 2A, prong 2, which is where you look for the practical application, sort of relates to Mayo Alice Step 2, which the Federal Circuit is looking at in its decisions. But Step 2B of the Patent Office guidance is more aligned with the Step 2 Mayo Alice Federal Circuit case law. So this is where another huge problem arises, where the guidance does not exactly align with the Federal Circuit, so it's kind of hard to figure out how to map everything together. The court actually looked at the differences between the two cases. So when it really determined that the Cosmo Key claim was eligible, it tried to distinguish the claim from the previous case. And this is how they did it. The court distinguished Universal Secure Registry, noting that Universal Secure Registry related to combining conventional authentication techniques to achieve only the expected result of the combination. In contrast, the court found the Cosmo Key case more similar to Ancora, which is the memory case that we first talked about, where verification methods that departed from earlier approaches were directed to non-abstract computer functionality improvement. So that's their reasoning, and I'll leave it to you to figure out if that makes any sense whatsoever. I want to show you a claim from a case that I personally dealt with the Patent Office in the same space as Cosmo Key and Universal Secure Registry. Here are the elements of a claim that I submitted on behalf of a client for, this is application number 12856-026. The method involved performing operations within a computer-implemented authentication architecture to authenticate an identity of a user before allowing or denying a request from the user to authorize a credit transaction. First, establish an authentication account. Receive authentication information. Receive a set of renewal rules, and the renewal rules specifying various information. Storing the one or more conditions in one or more profiles. And then in response to receiving a request from the user to authorize the transaction, determining whether the user has been validated. Okay? This claim, I went back and forth with the examiner for years trying to get it allowed. We finally appealed the case. We cited Universal Secure Registry and Cosmo Key, drawing a careful analogy to Cosmo Key, which is the favorable case. The board came down with a decision after we appealed it. The board's decision didn't even cite any of the cases, didn't look at any of the arguments that were made, and just rejected the claim as being ineligible for patenting with a very sparse analysis, without even looking at the arguments made by the examiner or my client. We filed a request for rehearing because the decision was so atrocious. The board denied our request for rehearing and then cited some of the case law that we had previously cited to and claimed that our case was more like the Universal Secure Registry case than the Cosmo Key case. It's very, very ridiculous stuff that happened here. My client decided not to appeal to the Federal Circuit, but it's just an example of where you end up, even when you go to the highest levels with a board request for rehearing, you will lose a case where you're clearly in the right, in my opinion. So this claim, I would like for everyone to take a look at this claim and see whether it's more like Universal Secure Registry or more like the favorable case, Cosmo Key. And I think the answer can only be one answer, and the Patent Office got it wrong. Okay. I think that's pretty much it for this presentation. I do have more slides that you can go through here, dealing with the Cosmo Key and the Universal Secure Registry case and this appeal that I took up on behalf of the client. I see there's a question here from Anthony. Assuming that your client uses generic computer components, like most do, what would you say are the best practices for a software processor case to avoid the examiner finding an abstract idea? Is it merely to state a technological problem and solution, or is there something else? How would you suggest handling ideas that are primarily user-based, e.g. QTech or InnovaPort? Okay, let's see. I think, we have a boilerplate often in our applications that show the computer. And within the boilerplate, there is a set of instructions. And as long as that set of instructions is tied to the novel elements, including the operations that are being performed, that are described in the specification, and as long as there is a technological problem and a technological solution described in the specification that method or those operations address, that's the key. So I think even when we have these so-called generic computer components, they aren't really generic because they include instructions. And inside those instructions are where the novelty lies. I do think sometimes the boilerplate needs to be updated to make it clear that although some of the computer components are well known, the set of instructions that are being executed are not. And that's where the big distinction lies. I've gone so far as to actually modify some of my language in the boilerplate to specify that this is a non-conventional, just to make the assertion that this is a non-conventional set of instructions that's being performed by the hardware. I think it's important to establish, or at least make an assertion, that what you're dealing with is not well-known, routine, or conventional, right? That's the test at step 2B in the USPTO's guidance. And so I like to make an assertion now, but still, it shouldn't matter that there's so-called generic computer components being used because of the instructions that are being executed. You said something about handling cases that are primarily user-based. Well, it shouldn't matter if it's user-based or not, because the technology usually has a server-side component, which is where usually you'll focus your claims, although it could be on the client as well. I'm not sure, Tony. I think I'm not sure about that last part there. And I'm not familiar with QTech or InnovaPort either. All right. If there aren't, I think we're done unless we have any more questions. We have about 5 more minutes left. Does anyone have any other questions? Okay, you mentioned the use of the 132 affidavits. Do you have any info about how they're shaken out? No, I don't have info. It's such a brand new idea to contemplate for most of us. I've never filed one. I know a couple of my colleagues have filed, but we don't have results yet, I don't think. But I do think it's an important consideration that we can now do this. Well, now the Patent Office has told the examiners that we might be doing this. So I think I actually plan to use these. I have a few difficult cases right now, and I'm going to have my inventors or someone familiar. Remember, it doesn't have to be the inventor. It's someone who's familiar with the facts of the case, who's an expert potentially. I'm going to have them file an affidavit. Seriously, I think this is the next step. Remember, the big concern with the affidavits, though, is creating estoppel. You do not want to characterize your claims as being more narrow than they are. Everything in the affidavit will be on the record. So that's the tricky part. And I plan to look at the memo, the first December memo. There's some very specific examples given at the end of that memo that can provide the guidance that we will need as attorneys to prepare the proper affidavit in particular cases. So I do think this could be a big step forward, an option at least, to advance those cases that are very difficult. Someone asked, should SMEDs be introduced only after final? I don't think that's a good question though. You have to look carefully at the timing of when the SMED can be filed, and there are some very specific rules around when it can be filed. I think it doesn't have to be after final. I think it can be any time during prosecution, but I could be wrong about that. I'd have to look very specifically at what those rules are. And the examiners are being told to make sure the rules regarding timing are being followed. So that's important to make sure you're following all the rules regarding the timing of when you file that. All right, I think we're done. Michelle, are you there?
Yep, sure am. Great job, Kurt, and thank you for joining us, everyone. Please join us for future SLW Institute webinars. Next Thursday is episode 1 of the SLW Quantum Computing webinar mini-series, when Laura Konitsky presents a practical guide to quantum technology for patent practitioners, moderated by Matt Norwood. And coming up also is the next episode of the SLW Chemistry and Biology webinar series, when Trevor Lind presents Legal Frameworks for AI in Life Sciences, Patent Law's Adaptation to Technological Innovation, moderated by Nicholas Lancetella. So please keep an eye out for those upcoming webinars in your email and LinkedIn. So thanks again, everyone, for joining us, and take care and be well.
All right. Well, you guys just witnessed the first webinar that I've put on Twitch. I've actually done several of these for my law firm over the years, but I thought I would give this a try to see how it went. I know this is not really that interesting to most people, that especially that are not attorneys, but I thought I would give this a try because I've been hearing that maybe I should change some of the content that I'm putting on Twitch to be focused more on legal stuff. So that's what Ice Poseidon told me, actually. Ice Poseidon gave me that recommendation. I see Janifest in there. Hey, Janifest. Janifest is an engineer, so I think she's probably worked with some patents, potentially, for some of the clients that she works for. Don't tell you what's interesting, Frank Bro. MRJ still here? Wow, okay. CK. You like the presentation, CK. Frank Pro, you're my biggest supporter. Beautiful presentation, he said. Well, I think that's it. That's cool that I got up to 20 viewers by the end. I wouldn't even normally stream in the morning, so. Oh, wait, redeem things? What do you mean, Jennifer? Oh, no, I don't think that would work too well. I couldn't even acknowledge the chat during that presentation at all. I should probably pin something saying that I can't respond to the chat during the presentation. Oh, you're a public policy guy, Break Bro. Okay. Yeah, there's a lot of public policy around patents. It's a huge amount of case law and patent office guidance and things that people deal with. It's all policy related. Like that example I gave of the ARP, the Appeal Review Panel. It's a weird procedure that only the commissioner of the patents can establish. This appeal review board, or panel, I mean, the ARP. And that's all policy stuff. And he came in and overturned a decision using the ARP because they're trying to increase AI patents in the US, or at least give applicants a better chance of getting a patent on their AI-related inventions. Ah, okay, CK. By the way, none of this is legal advice. None of us have an attorney-client relationship in this chat. But I can answer just from an educational perspective what CK is asking here. It does not matter if it's complete, CK. What happens is, if you can describe your idea in a way that one skilled in the art can make and use it, if you could just describe it, then you can get a patent on it. You do not have to have it actually working. It's called constructive, let's see, reduction to practice. It's called constructive reduction to practice, where you're able to describe your idea. Then it's considered to be eligible, once you put it down in words. So that's what I do as a patent attorney, actually, is I will record you describing your idea, right? And then I'll put it into the tools that I have, AI tools and other templates that I use to express it in a way that one skilled in the art can make and use it. One skilled in the art, by the way, is just a person, like an engineer, for example, or a software engineer for a software case would be an example of one skilled in the art. As long as that person can read what you've written and be able to implement it, then you can get a patent on it. Yeah, the educational info. That's right. A brave new world of legal conundrums with AI integrated into market. Yes. Well, AI's caused a lot of interesting changes to happen recently, especially with the work I'm doing. And there's also some new decisions, like from recently from either the Supreme Court or the Federal Circuit, where they determined that AI cannot be an inventor, right? So you cannot, an AI could never invent something. That's just the bottom line. It has to be a person. And I'm using AI tools now, a lot actually, in a sandbox at my firm, because all of our information that we get from clients has a client confidentiality, right? I have an attorney-client relationship with them. None of that could be released publicly. So if we cannot use ChatGPT or any public AI. So we have sandbox tools, which are only keeping all of our clients' information confidential, but allowing us to use these AI tools. And I'm able to use them now to create drawings, to help flesh out details of ideas. So like if an inventor comes to me and has an idea and I record everything they've told me about the idea, I can use the AI tools to flesh it out even more. Yeah, Killsoft, that's a good use of AI tools. I've been using AI for everything. AI's been so helpful with a lot of different projects that I've had recently. Like I built my streaming PC using ChatGPT to figure out all the connections and the components and everything that would be perfect for my streaming PC. And it worked pretty well. I mean, there's some things it didn't get right, but it helped a lot. Like I wouldn't have been able to do it without the detailed instructions that I got from ChatGPT. All right, well, guess what? Now we're going to raid out. Who should I raid? Let's figure out what's going on. Who's on Twitch? Let's raid someone for my E-Date show. You know, it'd be funny to raid Amaranth because she hates me, but I don't think I'm going to do that. Thank you, MRJ. By the way, I might be doing a karaoke battle on Friday. And then we have Mel Fire. Mel Fire's coming up on Saturday. I need to know who's going to be in for that show. And then Mayamu TV is the week after that. Maybe Moon Girl? No, maybe I should raid Amaranth, guys. I think that'd be funny. Let's see if she has bad things to say about me. Because I just did a legal stream, so I think it makes sense, right? She was claiming I was a fake attorney. Let's raid Amaranth. You can say fake lawyer raid. Yeah, that's the call. Oh, that's gonna be hilarious. All right. See you guys. Maybe Friday if I do the karaoke battle. Otherwise, Saturday we have Mel Fire. Bye, guys.